Welcome to the Cultural IP audio-visual series. Today we have a truly special guest joining us, Jennifer Stanley, a partner in the Technology Transactions Group at Fenwick & West LLP. Fenwick is a leading law firm for tech and life science companies, and Jennifer has been the go-to advisor for some of the biggest names in digital media, entertainment, consumer technologies, and retail for over 25 years. She's the leader of Fenwick's gaming practice, where she's counseled companies like Riot Games and Tencent in China. She counseled Airbnb as they scaled. She guided Amazon's Kindle app store launch and represents several other large tech companies, which services we use every single day, like OpenAI, Netflix, Robinhood, just to name a few. She has multiple decades of intellectual property deal-making experience, and is a leading legal authority on everything from AI to machine learning and the complex copyright issues implicated in both spaces. But with all of her legal, IP, and business knowledge, what I appreciate most about Jennifer is that she is as approachable as she is knowledgeable. Whether she's helping a first-year associate onboard to a law firm virtually during a pandemic, as she did for me, or she's helping startups break new ground, or advising the largest tech companies in the world, your creative and practical and down-to-earth approach is something that I personally value, Jennifer. So I'm excited. Thank you so much for your time. And I'll pass it over to you to further introduce yourself and speak a little about Fenwick.
Well, first of all, thank you so much, Jeremiah, for that incredibly generous introduction. I'm not sure I deserve all of it, but I very much appreciate it. And it is so wonderful to reconnect. I enjoyed the time that we had working together and looking forward to continuing our relationship from a professional perspective as you build your business. So as Jeremiah said, it has been my privilege and honor to have what sometimes I describe as a career beyond my wildest dreams at Fenwick, practicing law, looking at intellectual property issues, advising some of our most creative and innovative companies in the world, and having a lot of fun while doing so. As Jeremiah said, I've been at Fenwick for a long time, almost 25 years, and I'm based in San Francisco, so I truly get to see innovation in Silicon Valley from the ground up, which is one of the key reasons why I moved to the Bay Area from my home country of Ireland 25 years ago. So looking forward to a great discussion today about all the wonderful aspects of IP.
Great. Thank you, Jennifer. So as a partner at Fenwick, you work with the most innovative companies in the world. And for these companies, intellectual property and other intangible assets like data are the value drivers of the business. You work with startups as well. And as counsel for startups, sometimes you have to identify and define those IP assets for them early on so that they can maximize their freedom to operate as the business scales. So when you're talking to consumer-based startups, for example, they need answers, not legal theory. So how do you define intellectual property to them?
That's an excellent question, and it comes up almost daily in my practice. I start by identifying the fact that there are 4 baskets of IP or intellectual property that companies should focus on. This is not news to some of the people I speak to, but it is news to others because often by default, those of us who don't focus on the legal aspects equate IP to patents, and patents are absolutely an important element of the 4 baskets of IP, but patents are not the only kind of IP out there. So the 4 baskets are copyright, trademark, patents, and trade secrets. Copyright is an intellectual property right, which is a property right, something that a company or an individual can own, that attaches to an original work of authorship that is manifested in some kind of a tangible form, so long as it is creative in some way. What that really means in a nutshell is an idea is not protectable by copyright, but subject to the creativity bar and some other criteria, the manifestation of the idea could be protected by copyright. For example, software code is protected by copyright. I could write a poem. It may not be a very good one, but if it is sufficiently creative, that will be protected by copyright and I will own the copyright. A movie is protected by copyright, a piece of music, you get the idea. A patent is an intellectual property protective strategy that attaches to an invention, something that is non-obvious, something that gives competitive advantage from an invention perspective. A process to do something, a way to manufacture something, for example, could be patented. A trademark is a piece of intellectual property that most people in the world immediately understand because we can point to easily identifiable trademarks in the world. The Coca-Cola logo, for example. And a trademark is something that identifies and gives the consumer knowledge and often comfort about the source and the origin of a product or service. If I look at a Coca-Cola can and I see the iconic Coca-Cola trademark, the color, the look and feel of the can, I know that I am getting a product from the Coca-Cola company. I know what it's going to taste like. I know there is going to be consistency and uniformity on that product no matter where I purchase it anywhere in the world. The same applies for any trademark we can think of. Trademarks that attach to items of clothing, to businesses, to food items, you name it. And then the last area is trade secrets. And trade secrets are secrets, pieces of information that give companies a competitive advantage or some type of advantage commercially, usually, by the very fact that others don't know about this secret. And trade secret protection often comes into play, particularly for early stage companies when they're figuring out what their special sauce is going to be for their business, but haven't implemented a formal IP strategy yet. So those are the 4 baskets of IP that I get to talk about every day and ones that every business should be keeping top of mind.
Great, thank you. And in thinking about intangible assets more broadly, you mentioned the 4 categories of IP. There's also data, right? What category of IP is generally used to protect a company's data?
So it would, generally speaking, be a combination of copyright and trade secret. And trade secret dovetails into protection of confidential information. Confidential information is not always secret information, although sometimes it is. But confidential information is information that might be revealed from one person to another, one company to another, with a commitment to not tell anybody else the information that has been disclosed, or to only use it in a certain way and only disclose it to certain stakeholders who have reasons to know this information. So for data on its own, particularly individual pieces of data, may not necessarily on their own rise to the level of copyright protection because, as I said earlier, copyright must be creative in some way, and a factual piece of data on its own sometimes is not. But the compilation of data, a database, a data set, the fact that information, even factual information, is organized in a way that creates a product or that adds value can have copyright attached to it. So for businesses that are focused on data, trade secrets, confidential strategies to keep their data sets close or only share them with third parties with whom they want to share them. And in parallel, having a copyright protection strategy would be a good idea.
Yeah, that's great to know. I think that from a startup perspective, it's good to know that beyond contracts or beyond NDAs or beyond non-competes, which I know that there is ongoing discussion about non-competes at a federal level. It's good to know that there are also operational and legal steps to be able to protect data, or that businesses should potentially implement to protect their data. So that's very helpful.
And one thing I would add, Jeremiah, on copyright protection for data sets is that one doesn't need to register copyrights here in the United States to own copyrights. That is sometimes helpful and surprising and comforting information for some companies to hear, because the way copyright law works here in the US, and frankly in other places in the world too, is that the copyright protection attaches once the copyright protected work exists.
Right.
And so some companies worry that they have not registered their copyrights yet, and therefore worry that they don't own those copyrights, and that's not true.
Mm-hmm.
Once there is a protectable copyright element created by your business or by you as an individual, you own that. If you're running a company, your employees should have signed a piece of paper that confirms that you own it. Although even if they haven't signed a piece of paper, there are some legal doctrines in the United States for employees which will ensure that your company still owns the copyright protected works. And then if you're a business that employs independent contractors to provide services to you who are not your employees, and those independent contractors have signed a consulting agreement or a contracting agreement, then you will also own the things that they create for you.
Yeah, that's great. I think understanding the difference between common law protection, once an expression of an idea, a creative idea from a human author with some sort of human input, is fixed in a tangible medium of expression, that you have rights. That's good to know from a common law perspective, but can you speak on what are the benefits of going a step further and actually registering that copyright with the US Copyright Office?
So there's lots of advantages to registering the copyright. I want to be clear about that. One of the key advantages is it allows you to assert your copyrights. In other words, file a lawsuit if you believe somebody is infringing your copyrights. And it's actually a necessary step under US law from a litigation perspective to have a registered copyright, or to have attempted to register the copyright from a procedural perspective in order to assert those copyrights and file a lawsuit. And then coupled with that, and importantly, registered copyrights in the United States also allow a copyright owner to ask the court for what we call statutory damages. In other words, the copyright law enumerates dollar amounts, $750 per work through to $150,000 per work in certain circumstances if the infringement is willful. And it can be a very effective tool, particularly for those companies who don't want to go to the expense and effort of filing a lawsuit, but want to let an alleged infringer know that if they file a lawsuit, they have a registration and would be able to ask for statutory damages. It can be, as I said a moment ago, a very effective tool to deter people from continuing with infringing activity. And this is something that is commonly used when copyright owners hire lawyers to send what we call cease and desist letters. And if you receive a cease and desist letter and you know that the copyright owner has a registered copyright and can seek statutory damages, that can be enough to stop you in your tracks. There are some other advantages, including a presumption of protectability of your work, and you can get help with preventing pirated copies of works entering the country and things like that. So there are lots of advantages to registering copyrights here in the US, but it's not necessary to own the copyrights.
Thank you. And so transitioning to you and your career. So you went to law school in Ireland and studied in Brussels as well, correct?
Correct.
So what got you excited about IP as a field of law and business early in your career?
That is a really, really great question. And I have a very clear answer for it. When I was in my first year in law school back in Ireland, I studied tort law. I studied many other subjects, but tort stands out because I could see it in the world. I
Mm.
could see how individuals interact with a legal principle. If something happens to me, I have some remedies.
Mm.
And then in my second year, I took IP, and that was game over for me. I was like, this is it. This is what I want to do for the rest of my life, because it was taking that concept of I can see this in the world
Yes.
and I can explain to people what intellectual property is, like I did earlier in this discussion, and people understand what that means. And
Right.
then I can further have fun with it
Yeah.
and represent the kind of companies that you identified at the beginning of this conversation. Video game companies. Copyright, for example, attaches to many elements of a video game. The sharing economy. We
Yes.
can see products and services that we use in our day-to-day lives. So I just decided this is it for me. This is what I want to do. I can talk about what I do at a cocktail party, even though I'm a lawyer, and people will really understand it. And when I came to Silicon Valley, I wanted to come to California because I wanted to see technology law on the ground at that time. I was seeing technology law in the late 90s in Ireland from a different perspective on the other side of the world. And when I came to the Bay Area, when I came to Fenwick and got to work with some of the most innovative companies in the world and got to literally see the future,
Right.
literally see cool and exciting products years before the rest of the world saw them, there was no way I was ever going to look back. So that's really how I got into IP.
Yeah, I love it. I'm not sure if you remember this, but I remember you saying this to me that as an intellectual property lawyer, attorney, advisor, you're really an innovation lawyer, right?
I think
And
that's right.
yes, that really stuck out to me. I remember that I think it was on a panel during the pandemic that you said that to the first years at the time. So I appreciate you imparting that on me, and I
Well,
love
it's exactly right. And to expand on that a little, if I may,
this.
we get to apply the law to really cool, innovative products and services. And sometimes the law hasn't quite caught up
Right,
what companies are doing from a creative perspective. And so, as lawyers, we get to take the existing doctrines that we're familiar with and then help our clients figure out to literally play within the rules, sometimes bend those rules because the law needs to develop. And sometimes new law is created. And there are so many different examples of how that manifests itself. For example, there was a time when the internet didn't exist. Most of us can't remember that. There was a time when search didn't exist.
mm,
And search, I think, is an interesting one because the ubiquitous exercise of opening a browser and opening a search bar and typing in a request for some information was once something that was hotly litigated.
mm.
Is there copyright infringement going on? Should this be allowed? Is this going to cannibalize other businesses? And there was lots of litigation, and the end of that story we all know is turns out search actually is okay. It does exist.
Right,
And we're seeing a lot of similar issues with generative AI right now.
right,
And generative AI and the use of generative AI and how cool and innovative and fun and exciting it can be to use some kind of LLM to create content, to create fun images, to help you write your great American novel, whatever it is. is something that is relatively new and exciting now, and there are lots of legal issues that come into play. And my prediction is that years from now, Jeremiah, if you and I are sitting having another Zoom or some other version of this technology that perhaps we can't even predict right now, we will know where the parameters for something like generative AI landed. We don't know that yet because there's lots of open questions about whether there's copyright infringing activity going on or not, and how we can combine supporting innovation from a worldview perspective with protecting the owners of intellectual property rights. So we really do get to see the future as technology lawyers, as intellectual property lawyers. The future is always going to be there. So we are always going to be able to see the future, whether it's tomorrow, next week, next year, 5 years from now, and so on.
Yes. We're going to get into the AI question at the end. But before that, you did mention that you literally help businesses play within the rules. That was probably a reference to your gaming group. And you're the head of Fenwick's gaming group, and you counsel some of the largest gaming and entertainment companies in the world. So obviously, you have to be familiar with the product, right? Which requires you carving out time to play some video games. So I'm curious, which are your favorite games to play? And are there any specific IP issues that you've dealt with in helping to commercialize one of your favorite games?
So I'm going to controversially not answer your first question because I represent a lot of different game companies and I couldn't possibly pick my favorite child. But the IP issues that we deal with range from looking at the characters and the storylines and the composition of some of the games to help our clients think through whether it is okay to include this kind of visual representation or that kind of visual representation. Our practice does involve playing a lot of games, so you are actually absolutely correct. And a typical project for me and my team, and of course I have a team, I do not do this on my own, could be to review a gameplay experience or review images or video content that is going to show up in a game, and do some analysis and decide whether we think characters, visual representations, etc., are unique enough or perhaps should be modified in some way. And sometimes the direction is that looks great. Sometimes the direction is I think you should change some things about that character, maybe change the outfit, maybe change the hair color, maybe change literally everything about the character, including the size of the ears, the color of the eyes, the name, the special magic tool that the character has, and so on and so forth. But it is a very fun experience to be able to do that.
Yes. It's so interesting too, hearing you speak enthusiastically about games and really recognizing how the different categories of IP that you mentioned at the beginning can intersect with just one game, from the code on the copyright side to the images on the copyright side to maybe even the trademark of the particular game. I'm not sure how patents would necessarily intersect, but I'm sure you've seen that as well. And definitely trade secrets with data and know-how. And so it's just so interesting how one piece of entertainment, right, can really be covered by all aspects of IP.
Absolutely. And in fact, even different components of a game have their own individual IP elements. For example, if there's music in a game, there's a separate copyright protection in the piece of music.
Right.
If there is some cool audio content that isn't music, there can be separate copyright protection there. The visual representation, the software code, the compilation of the game overall. So there are lots of different elements that have their own individual protections as well. And there can be some cool, innovative patent technologies, how certain things are presented in a game, sometimes how different special effects work in a game can be inventive and protected by patents too.
Really interesting. So transitioning to family life and IP, you have teenage sons, yes?
Correct? Age 19 and 16.
Oh, okay. So no longer teenagers, truly, at this point. Maybe
Well, they're still teens.
okay. In their mind, I'm sure they're not. So, two teenage sons, what consumer tech products and services are they interested in? And are they aware, as you are, just how much intellectual property implicates their everyday communication online, how they work and entertain themselves? What are the IP conversations like with your two teenagers in the household?
So we are self-proclaimed the IP nerds in our household.
Love
My
it.
husband is a software engineer. We live here in the Bay Area, and we are enthusiastic consumers of tech products and services. So we talk about these issues a lot. Both of my boys love video games and over the years have played the games of most of my clients' games. And they all have their favorites, of course. And then they also interact with social media and any of the products and services that their schools and colleges offer. And one of the things that we've spoken about a lot over the dinner table over the years is the desire to allow people to protect their creative intellectual endeavors and commercialize those and monetize those, and look at that in the context of what should be available to
Mm.
the world at large. And there isn't always agreement on this point. Generationally, there can be an expectation that some content should be freely available, meaning available without permission, not necessarily without cost, but without permission. And then other times, particularly when the boys are creating something that is cool, they understand that this should be something I should be able to own and monetize myself. They both also love card games, particularly Magic the Gathering. And there's a lot of very, very creative, beautiful, artistic elements to a Magic card, for example, for those of our audience who are familiar with that game. And to be able to protect and enjoy the benefit of the protection of some of those creative endeavors is something both my sons feel very passionately about from the creator's perspective. So it's a very robust and fun conversation. It's really fun to see it in day-to-day life. There's obviously some interesting conversations about the use of AI solutions for school. Usually the direction is don't do your homework by yourself, use your brain. But also we understand, all of us, I think, as any person surviving in the 21st century understands, we should and must take advantage of technology. We must continue to support innovation. And one of the ways to do that is to use tech products and services.
Right. So speaking about AI and wrapping up here, the challenge for all categories of intellectual property is how to adapt them to new technology. And the copyright system, as you mentioned earlier, is really just in the latest chapter in the relationship between copyright and technology with generative AI. I'm sure that you saw the US Copyright Office, which, for our audience, the Copyright Office advises Congress on copyright matters, provides assistance to courts and executive agencies, and puts out studies on major copyright issues. Their most recent report was part one of their copyright and AI report that was released on July 31st. And part one focuses on digital replicas and the issue of using digital technology to realistically replicate an individual's voice and appearance. The Copyright Office sought comments over the course of almost 2 years, asking whether existing laws provide sufficient protection against unauthorized digital replicas, or if new laws are needed at the federal level. And in this report, from my understanding, they concluded that a new law is needed, that existing laws are not sufficient to protect against unauthorized use of aspects of an individual's persona. So, Jennifer, what are your thoughts on the Copyright Office saying, hey, we need new laws specifically for replicating an individual's voice and appearance?
I think it is terrific when we have our legal system, and I use that term intentionally very broadly because the Copyright Office is part of our legal system, but we have many different elements of our legal system, including the courts and Congress and different legislative bodies at the state level and so on throughout the country. So it's very important that our legal system is engaging in a conversation like this and seeing the necessity to allow the encouragement of innovation, which is something obviously that's very important to the Copyright Office with the reality of how technology works now. And there are some thorny questions that are being litigated right now vis-a-vis the use of third-party data to train LLMs. And then the Copyright Office itself has struggled, I think is a reasonable word, with how to think about whether the outputs of an LLM are even protectable by copyright. So it wasn't surprising to me, and it was encouraging to me to hear what the Copyright Office was saying to the country in July. Because if we find ourselves in a place where we're not sure whether the output of an LLM is protected by copyright or not, and here in the United States right now, it's not in its raw form, then we extrapolate it to the next level, the digital replica of an individual, the elements of an individual visually represented, audio representations of a voice, visual representations of a mannerism, things like that, are all part of what can be an output. And whether we need to apply existing law, which is not easy, or find a amendment or variation on existing law to address the innovation is really important. And I think it's exciting. I think a lot of the stakeholders in the industry on all sides will welcome some legal innovation from a legislative perspective too, to help solve some of those problems.
Great. Thank you so much, Jennifer, for your time, the information. Really excited about what's happening with IP right now. And I know that there's a lot of unanswered questions, and it may seem like to the general public that IP is sort of at a crossroads, but always think back to Article 1, Section 8, Clause 8 of the U.S. Constitution to promote the sciences and the arts. And I know that that's always going to be the result and the entailments of any advancements in technology, and how IP is able to safeguard it and incentivize us to continue to create. So thank you so much for your time. If you have any last parting words, please feel free to share them with the audience.
So I love that you quoted the Constitution. I think there's no better way to end this conversation except for me to say it's always a pleasure chatting with you, and I look forward to continuing this conversation. Let's see where we end up in the future on this point. So thank you so much.
Thank you, Jennifer. I really appreciate it.